Good evening. Happy Tuesday. Today, Jose Decastro is going to give us a master class in fractal stupidity. We're going to go down a trip down memory lane here, just to start it off. On November 10th, Chili Decastro filed plaintiff's notice of voluntary dismissal without prejudice. Now remember, this is after Kate and Josh had filed their answers and counterclaims on the 7th. So on the 10th, he filed his notice of voluntary dismissal without prejudice. The court said, no, I don't believe your story amounts to anything that makes me want to allow you to dismiss, and the defendants have answered. So, no. That was on the 10th as well. So Chili decides on the 11th to file a motion to correct the record. Or alternatively, a motion to reconsider, motion to transfer venue. The operative part of this is the motion to correct the record. Chili wants the court to move his notice of voluntary dismissal to be filed on the 6th, prior to Kate and Josh. Then, as luck would have it, on November... I have two of these. Oh no, I'm sorry. He then files an amended one and doesn't label it as amended. They are both labeled motion to correct the record. The only difference between the two, as far as I'm aware, is that one has fewer exhibits attached and the other one has more. The judge on November 16th, 5 days later, says no, because what Chili had done in the meantime was he had filed an amended complaint. So he's lost. It's done. We're moving on. Chili says, hold on. I'm going to file a motion for reconsideration of the motion to correct the record. Or alternatively, file an amended motion to correct dated Nunc pro tunc. So he's asking for leave to file a motion to correct the record dated Nunc pro tunc. So reconsideration or file a motion to correct the record Nunc pro tunc, as if the court was stupid enough that the court didn't understand what the court was ruling on when it made its previous order. And then the court said, no. How about no? You filed an amended complaint. No. No. So Chili's like, you know what I should do at this point? I should file another motion to correct the record. Because what that stupid fucking judge didn't understand was I really, really want to correct the record. Oh my God. This guy's dumb as dog shit. Jesus fucking Christ. All right. So let's look at this one here. So we have on page 2, this one, Federal Rules of Civil Procedure 41A1A1. We have 41A1A1. We have, I filed a notice. The court doesn't appear to have made an investigation, so I'm moving the court to do so. I filed a notice. The court doesn't appear to have made an investigation, so I'm moving to do so. The court has said that I did not explain fully, yada, yada, yada. I expect the NVD to appear on. The court has explained that I did not refile the document until it appeared. I expect the end. Do you see the problem here? Let's go down here. The court said I submitted no evidence to show I drafted the NVD. The court has said that I submitted no evidence to when I drafted my NVD. I'm treating it as IU. I'm treating it as IU. How about we're going to do defendant attorneys have suddenly gotten dumb. No, wait. We need to include the most important thing here. We need to include the most important thing. Non-party attorney John Rietveld. Oh, that's a sexy bastard right there. Non-party attorney John Rietveld. The defendant attorneys have suddenly gotten dumb. And we already showed earlier here, the defendant attorneys have suddenly gotten dumb. I'm just showing you everything's in the same place. I've raised my concerns on my MTV. Oh, we've got to change. Oh, we've got to change. Finally, ask for reconsideration of this motion. Then we have finally case law. Oh, this is a change. All right. Finally, case law has indicated the requirements of the ECF system do not affect whether a document is filed, and the court's IT personnel should be able to show minimally how far along the filing process. Wait, that sounds familiar. That sounds familiar. Where did I see that before? Where did I see that before? It was this one. No? Where did I see it before? This one. It's 60. I don't have 60. Hold on a second. Hold on a second. Sorry, you get to come along for the ride, kids. Let's see. 60, 60, 60. So we're going to go here. Where did I see it before? Necessary steps to preserve my right to appeal. Where did you get that extra line from? Is that it? That you just had that one extra line? think it was this one. I think I'm just maybe remembering that line from one of these cases that I read. It was probably probably this case. So that's where he got this stuff. And then so he's added one line of argument, and then he has a points in authority. We've got Phoenix Globe Adventures. We've got this string of cases again, and that was this string of cases. And then we've got a block in here, and I think he just turned this into a block. Pentimely. Seville v. Stotsky. Is this a new one? All right, we got Seville v. Stotsky. This one from 2009, the court deemed a pro se litigant's remand motion made on the date it was signed and dated rather than the date it was filed. This is a district court decision at the Eastern District of Pennsylvania. Let's see if we can actually find it. It doesn't appear to be a published decision. Does not appear to be a published decision. I don't know why anybody is quoting unpublished decisions, but I guess you can. It is an unreported decision. Where he was a prisoner. Now this is from 2013. Okay, so on this one, so it appears this is where a prisoner was going to file something. He did not have access to ECF, so he gave it to somebody to file it. And in addition, the statute requires a plaintiff's motion to remand must be made, not filed, within 30 days of the filing of the notice of removal. And the defendants filed their... So this has considerations that unfortunately don't apply to Chili's situation. Chili's not a prisoner. He's not handing his paperwork to a guard or someone else, or mailing it to someone where it would then have to be scanned into the ECF system. Chili had access to the ECF system, so this one doesn't apply. He wasn't just a pro se litigant, it was a prisoner. B, declaration is sufficient to prove error. This might be new. He's citing the same Phoenix Globe Adventures. Okay, so we've got... I think he put the citation above it. I normally see it below, but that's not an issue. Associates argue there was no evidence corroborating Giuliano's attempt to file. In reviewing district court decisions for abuse of discretion, we review the underlying factual findings for clear error. So this is a standard of review. So Giuliano submitted a statement that affirmed his account to be true on penalty of perjury. Associates never requested an evidentiary hearing or otherwise tested the statement below. It is apparent that the district court credited this account, although it did not say so explicitly. While Giuliano's statement is, as associates point out, slightly vague and phrased in a passive voice, we do not find it sufficient to make the district court's acceptance of Giuliano's statement clearly erroneous. But you see, what this is saying is that an appeals court is going to defer to a district court's finding of fact. And if the district court believes a declaration, great. And if it doesn't believe a declaration, then also great. It doesn't help him, is really what I'm trying to say. Notice of defendant sufficient for notices required to be filed with the court. Okay, Houston versus Lack, Rules 3A and 4A1 specify the notion should be filed with the clerk of the district court. This is from 1988, so let's check out FRCP Rule 3A. Rule 3 is on commencing an action. What the hell? You might hear my wife snoring. We live a very exciting life. All right, let's check out Houston versus Lack. To the Googles, my friend. And where are we at in Houston versus Lack? And we don't get a page citation. So let's figure out what we're dealing with here. So it's a habeas corpus. And so we're talking about Federal Rules of Appellate Procedure. Let's just go there. So Rule 3A, what was it? What did he think he was dealing with? Rule 3A and 4A1, notices should be filed with clerk of the district court. Not you. You. 3A1. Filing a notice of appeal with the district court. Yeah. So an appeal that has nothing to do with what we're dealing with here. And Rule 4, I'm also going to guess, is going to deal with appeal. Come on, dude. Yeah, the notice of appeal. Dealing with notices of appeal, absolutely nothing to do with the case at hand. So I don't know why. This has nothing. It's useless. And it's dealing with the notice being filed with. It doesn't say that. It doesn't say that. Notice to defend. Where does it say notice to defendants is sufficient for notices required to be filed with the court? And again, see, you're dealing with someone filing a habeas. So when the person gives the notice to the prison authorities for them to give to the clerk of the court, that could be where the court is looking at in Houston versus Lack. I'm not going to read Houston versus Lack, but you can see it's dealing with prison authorities. So it's going to, again, be a question of when was the habeas filed? Was it filed when the prisoner gave it to the prison authorities to deliver to the clerk of the district court, or when it actually arrived at the clerk of the district court? And usually those questions arise when there's a delay, when the prison authorities sit on the paperwork. All right, evidentiary hearing allowed in a motion to correct, and the courts have testified as to filing. This was the board of whatever. I think we went over this one the last time. Yeah. And so it has the same problems. Tolling should not occur where they exercise diligence and lack of fault. Well, here's your problem. The court has already found that there wasn't a lack of fault on Chili's behalf, and there wasn't diligence. Or at least the court hasn't found there was diligence and lack of fault. So you just read this. The equitable tolling doctrine extends, actually you might not be able to, the equitable tolling doctrine extends to statutory deadlines in extraordinary circumstances for parties who were prevented from complying with them through no fault or lack of diligence on their own. And you can see where something like this might happen. Like let's say you're in Florida and it's your deadline to file, but there's a hurricane and all the power's out and all the internet's out and you can't file. It's not your fault. You can't file. So you file as soon as you can. As soon as you get the ability to file, you file, and you include with it an explanation. You don't wait, if you thought you were supposed to file on the 6th and you wait till the 10th before you do file, that's not, you've wasted time. And also, one other thing is this is dealing with like a statute of limitations or a statutory deadline. You didn't have a deadline necessarily to file your notice of voluntary dismissal. Well, maybe you did. I'm going to back off on that one. That's a finer point that I don't think is really a court would appreciate. Nunc pro tunc is proper and changes history. Oh, this is going to hurt me, isn't it? Whether this is a nunc pro tunc, this is Fierro versus Reno. Whether this is a proper nunc pro tunc order under state law is open to question. Why are we talking about state law? Why are we talking about state law? It goes on, like many other concepts in the law wrongly assumed to have a fixed meaning, nunc pro tunc is a somewhat loose concept like jurisdiction or waiver, used somewhat differently by different courts in different contexts. So this court is talking about state law, And it's saying that under state law, the state, presumably, of Massachusetts, Massachusetts, might use it differently than the federal court does. That's what they're talking about. Literally meaning now for then, yada yada is a phrase typically used by courts to specify that an order entered at a later date should be given effect retroactive to an earlier date. That is, it should be treated for legal purposes as if entered on the earlier date. This stupid idiot is thinking that the court does not understand what nunc pro tunc means. He's trying to educate the court. He's thinking the problem is that the court just doesn't understand what nunc pro tunc is. Not that the court thinks that it's not just or equitable to do what Chili's asking, but the court just doesn't understand. The court's just stupid. It's not that the court it can't be just that the court doesn't buy his argument. It's the court doesn't understand his argument. That's a very poor tact to take with anybody, really. It's thinking that it's not that they don't understand the argument, it's not that they disagree with the argument, it's that they just don't understand the argument. You're just too stupid to understand. If only you were smart enough to understand the argument, you would agree with me. Very condescending. The critical question here is not the intended effect of the phrase, but in what circumstances a court may properly order a new judgment be given effect to nunc pro tunc. So first of all, we're dealing with state law, and instead of motions, we're dealing with judgments. The core notion in Massachusetts is that nunc pro tunc order is appropriate primarily to correct the record at a later date to make the record reflect what the court or other body actually intended to do at an earlier date, but did not sufficiently express or did not get around to doing it through some error or inadvertence. Thus, a clerical mistake in a judgment, this is not a clerical mistake in a judgment, may be corrected nunc pro tunc when discovered later, or a franchise sought as of October 1st might be backdated to that date where the application was timely made. Oh, where the application was timely made. Isn't that weird? Isn't that weird? Declaration, I declare under penalty of perjury the foregoing is true and correct. He's actually hit the high notes. Now, I don't think that he's done an affidavit like he's supposed to do. The local rules, these are local rules for motion practice. Affidavits, a party filing a motion shall at the same time file a memorandum of reasons, including citation of supporting authorities why the motion should be granted. Affidavits and other documents setting forth or evidencing facts on which the motion is based shall be filed with the motion. I think he's doing not too bad on actually hitting the and this is close enough. Request for hearing, he's not going to get an evidentiary hearing. He's not going to get an oral argument. Sorry. And, yeah. So there you go. Ooh, we got exhibits. Oh, have we seen these exhibits before? It's not that one. Is it this one? Yep. Okay, so we've seen that exhibit before. Exhibit 2. Have we seen Exhibit 2 before? Let's see if we've seen Exhibit 3 is the email to Wish. Exhibit 3 is the email to Wish. Exhibit 4 is the email to Joshua Garrick. Exhibit 4 is Josh Garrett. And that should be it. And that's it. Okay, so it's essentially the same motion. He's throwing in a few other citations that aren't going to help him. And that's about it. And instead of styling it as a motion for reconsideration, which it is, it's a motion for reconsideration of his motion for reconsideration of his motion to correct the record. He's now styling it as a new motion to correct the record. This is the territory where the court can, of its own power, start to sanction. this is abusive. Filing the same motion 3 times in a row with essentially cosmetic changes. That's when the court's going to start to get upset. That's when you might see the court start to take its gloves off. And it was probably not good timing to do this right before the court considers contempt. I would have let the court get through whatever it was going to do on contempt. And I'll tell you why. It's because, courts are pretty good, generally speaking, about not getting prejudiced by stupid attorneys and stupid pro se litigants. They generally don't get too prejudiced by it. But if you start doing things like abusing the legal process by filing the same motion for the 3rd time after the court has clearly stated 3 times. The court clearly stated it once. No, I don't believe you. I understand the facts. The court lays out the facts. I understand these facts. And despite that, no. And then again, the court understands and no. You filed an amended complaint. It's done. And then he goes again, and the court again lays it out. Look, I understand and no. And then he goes back again. That's going to wear on the court's patience. I don't think the court is going to wait for Josh Garrick or Benjamin Wish to file any opposition to this. I strongly suspect the court is sua sponte, just going to enter an order denying this. And at this point, I think the court might threaten sanctions for further abuse of process. I assume the court's going to say, Mr. Decastro, this is done. This is done. You've preserved it for appeal. If you lose on the merits, you can take this up on appeal. But in this court, it's done. And if you bring it up again, I'm going to sanction you. Or the court will probably soften that. If you bring it up again, you may be subject to sanctions, including but not limited to blah, blah, blah. But then right after doing that, the court's going to have to decide on this contempt thing. And that could color the court's opinion. So anyway, that's all we got for today. Thanks for watching. I'm sorry for all the boring spots when I'm looking through and trying to figure things out. But I'm not going to record this again because my wife's falling asleep and I want to kiss her goodnight before she goes to bed. Thanks for watching. Have a great day.